Yes, we are live. I'm attorney Justin Sterling. I'm a personal injury and business lawyer. This is Coffee with a Lawyer, streaming live on YouTube, Facebook, Instagram, LinkedIn. This is your chance to ask the lawyer your legal questions for free. This is why I do what I do, to help people deal with legal issues, improve their lives, and make a meaningful difference. Please know there is no attorney-client relationship, no confidentiality here. This is important because what we say here could be discoverable if you are in any litigation. So this is only meant to provide general information and is not specific legal advice. And today we have special guests. So all I ask is to keep your questions general. If you need to ask specific legal advice, I encourage you to arrange a confidential consultation. Again, this is not confidential. There is no attorney-client relationship. Attorney-client privilege doesn't extend to what we discuss here. And I'd like to call on iPhone because I know you signed on first. And if anyone's in the chat, please feel free to type in a question and I'll try to get to it as best as I can. Let's try to be brief because we have multiple guests here and I want to try to get to everyone. And let's also try to also give each people the respect and not speak when others are talking. So iPhone, if you'd like to ask your question, and then I will go to AP and then ZH in the order of when you signed on. Does that sound fair? Thumbs up? That's okay? Okay. So iPhone, are you with us?
I am. I can just listen in today. I don't have any new questions, so we can proceed. Thank you.
Okay, I understand. And I know we talked a little bit earlier, so if you give me that summary, and guys, my email's in the chat. If I can't help you, I'll do my best to find an attorney who can. But what I would need from you is to email me a brief summary, a 3 to 5 sentence paragraph of what exactly you have going on. And I will send it out to my network and provide me your information for them to reach out to you. And I'll do my best to try to find you an attorney who can help you if I cannot assist. AP, would you like to ask your question? Go ahead, you can unmute.
I'm sorry. I'm just curious to know a couple of things regarding you being a business lawyer. What kind of cases do you take? What is all that entails in regard? What's the retainer fee? And if there's a higher retainer fee if you are in a different state than your practice is located.
Okay, thank you for the question. So business law is quite broad. It involves a number of different areas of law. It could be transactional, it could be litigation. My experience is as a litigator. I was brought up as a litigator. So I know how to file complaints, I know how to do discovery, and I know how to prepare a case all the way up to and including trial and take it to verdict, which I believe is most important because you'll see you may come across strictly transactional attorneys that will help you with your contracts. But when there becomes a dispute, a lot of times those same attorneys will say, I can't help you. I drafted this deal for you. I made this document that gave you certain rights and made you obligated. But now because there's an issue, now I can't help you. You got to go find someone else. To me, that is not fair because you are the professional that drafted this document, that arranged the relationship among the parties. You know it best. You should be able to take it into court and assert people's rights in order to resolve a dispute. So my litigation experience and training helps me with my transactional practice, drafting contracts, helping people enter into deals with other people. The law is all about how we relate to each other, even contracts. The paper that you sign is just evidence of what your agreement is. A contract is an agreement to be bound. It's to hold people to their promises. A papered signed document isn't even necessary to have a executed effective contract. A contract is all about mutual assent, holding people to their promises, responsibility and accountability. So my experience as a litigator, and I do believe every attorney, and look, much respect for transactional attorneys. It is difficult to draft contracts, to ascertain what the people want in this deal and what they're willing to give up and what they will get back in return, the legal consideration. That's difficult, you know, and to inform your client what exactly their rights are in this arrangement. That's difficult. But I do believe every attorney should have the knowledge and the experience and the know-how of how to access the courts, because that is where we go in our civil society to resolve our disputes. The doors of the courthouse are open, and we need to know how to get in there, or else you're going to be abandoning your client. And I don't believe in that. Yes, some attorneys may say you got to focus and niche and only be able to do contracts for clients. But I still believe, and this is my personal belief, you need to be able to file a complaint and handle the litigation process and advocate and represent your clients in front of a jury. That's what I firmly believe. And then as far as, it was a couple parts to your question, as far as fees, by law and by the code of ethics, all attorneys' fees must be reasonable. All right. It cannot be an unconscionable fee. It has to be a reasonable fee, and that's by law. And they must be negotiable, which means attorneys, you know, it could be take it, you know, they can't really present you a take it or leave it arrangement. It is negotiable, and they have to inform you that their fee is negotiable. So those are the codes of professional conduct that we have to abide by. We have to inform you that our fees are negotiable. Usually that means in our retainer agreements, that somewhere in those provisions, we make it clear, we make it known that the fees are negotiable. I hope that answers your question. I don't know if you would like to go a little bit further into that. I'd like to give you some more time. I know I said a lot there. I don't know if that gives you any more insight, or if you'd like to ask something else.
That's fine.
Yeah. I do know you had some LLC questions, and LLCs are important because it separates your personal liability from your business liability, which is the main protection there, the corporate shield. The LLC is the more popular business formation because it gives you the flexibility of operating like a partnership and the pass-through taxation. But it also gives you the legal protections of a corporation with the corporate shield to protect your personal assets, which is very important, because if you are doing business and you have creditors, or you get a judgment creditor, you're involved in a lawsuit, they can only reach what is in the business. They cannot access, for example, if you own a home in your name or other personal assets in your name. So it creates a protection, which is important. So that's the main importance of an LLC. And if you're in the entertainment industries, there are different type of models you may want to follow. For example, you may have an operating LLC, an umbrella LLC with individual project LLCs to protect the capital that you raise for each one of those individual projects, so that if you do ever have creditors for that individual project, they can't extend further and reach your operating business assets. They can only reach what's in that individual project LLC. An umbrella operating LLC and individual project LLCs. It depends, though, because you want to evaluate whether the project is worth going through the steps and the expenses of creating a new LLC. Is it at that stage yet? Does that make sense to you?
Yes, no problem.
Sometimes real estate professionals structure their operations in the same way. I do want to give ZH or ZY, excuse me, an opportunity to ask her question. I know you had some litigation matters. And guys, what I would like to ask, I do want to get in the practice of asking, because I do really want to be of service to as many people as I can. And so a great way to say thank you, and which would allow me to help others in the same way that I can help you, is by leaving a positive, kind review. I put the link to leave a kind, positive review on my Google profile in the chat. And although you're not required, I'm not requiring you to leave a review. Just by showing up is enough. You know, allowing me to be of service is enough. But I would be extremely grateful and honored if you were to leave me a positive review. And the link's in the chat. So I just wanted to put that out there. ZY, and I do know there's some people that are messaging in the chat. If you want to post your question in the chat, I am seeing it. And as soon as I can, I will get to it. But I do encourage you guys to listen, because we can learn from others here. The information could apply to a situation you may have experienced or may experience in the future. So information is power. So I'm here to be of service and share what I can do to help. ZY?
Yeah. Hi. I'm Hui Yan. I would
Well,
like to...
ma'am, sorry to interject. And sometimes I may interject, not to be impolite or rude, just because I need to lead the conversation. Let's try to refrain from indicating any personal identifying information, because again, I need to make clear what we say here is not privileged. This is not confidential. And if you are in the middle of litigation, which I know some people here are, this information, what we say here, could be discoverable. So we want to be careful what we share. Let's only speak in general terms. Let's not use names. I'm trying to use abbreviations as best I can to protect identity, because I do also want to make sure that, you know, by sharing what we say here, it doesn't come back to hurt you in any way. So let's speak in general terms. If we got to go further into specifics, I encourage you to schedule a confidential consultation.
Okay. So my friend get injured, then I found a personal injury attorney to represent him to pursue the injury case. So I signed the contract with the attorney, represent my friend as a guardian ad litem and the trustee, guardian ad litem. So then the attorney sent the petition to get me appointed as a guardian ad litem of my friend to pursue the personal injury case. So then after maybe 2 years, we reached the contract says the attorney cannot enter into any settlement or compromise claim without my consent. That's in the contract says. Then after we went to mediation, we reached the agreement with the defendants. So which said to the couple $3 million of the settlement out to my friend. So then I had a question about the attorney's fee, because at the time we signed the contract, he explained to me, you know, because the medical bill is huge, which the compensation may not be able to cover the medical bill, which the workers' compensation insurance would put a lien on the case. So it's involved to the person workers' compensation case. So then I managed to have another agreement with the workers' compensation insurance, which waived the $2 million of lien against the personal injury case. So after we reached the agreement, then he said, first that he said that if they cannot cover medical bill because it has a future medical bill and the past medical bill, so then then we can agree with the 1/3 of the fee. He would get it, like for example, 3 million. He would get 1/3 of the 3 million. Then my friend can get 1/3 of the coverage, and the medical lien can get 1/3. So then after we reached the agreement, he did not agree. He said no, he wants to get the 45%, which would be 1.3 some billion. It's more than he agreed, explained to me, but anyhow, so he did not agree. Then he did not want to ask a request for my guardian ad litem fee and the cost, because my friend lives at my house. I spent lots of time and money to help him recover. So I submitted my fee. Then he refused to do that. Then he ended up, he just managed to get a conservator, which he appointed by another court, like a probate court. So he managed to talk to the attorney, court-appointed attorney, to remove me as a conservator of my friend. Then they brought another conservator to the case. Then says the conservator said, a professional conservator said that they don't want me, they don't want the attorney to consider my guardian ad litem fee and the cost. So then she signed the agreement without my consent, which is violated the contract with the attorney, because they say they have to have my consent before they enter into any settlement. So then end up, I think the trial court made a decision to delay my fee request because he did not put the fee on the compromise claim petition, and I filed the objection. Then the trial court made the decision to not consider my fee
Well, ma'am, I'm going to interject here because there's a lot there.
Yeah.
And I don't know if you are trying to seek representation for this matter, because right now, I mean, you probably should seek representation to, but
right.
Some guidance though. You got to take it one step at a time.
Yeah, right.
No attorney is going to be able to follow everything you put out there. Although I've been taking notes, and I put my notes in the chat.
I have not complete. So I went to appeal. I filed the appeal. Then right now the appeal decision came out. It says the court should consider my fee. So that's what and remanded to the trial court to determine the reasonable fee. So then end up I spend a lot of attorney fee for the appeal. So I would like to get the some attorney to represent me to request that.
I understand, ma'am. I understand, ma'am. I mean, to help you get an attorney, what I would encourage you to do is to type out a detailed chronology, a timeline. You have to tighten up your story. Although you did a great job. You did a great job of explaining this to me. But there's a lot there, and it needs to be in writing. So let's draft a timeline of the key facts and the key events in your matter. And a lot of it deals with attorney's fees. What I would suggest is my advice to you is to request mandatory fee arbitration with your attorney. Get into a proceeding, get it resolved, get the fee dispute resolved. All right. So a fee dispute between an attorney and a client is subjected to a fee arbitration. All right. So look into them. I've never been in a fee dispute with my clients because I usually accommodate their requests. I'm there to help my clients. Now, other attorneys may take a different mindset. I mean, you're dealing with a lot of money. It was a large settlement. A large settlement. both the workers' comp attorney and the personal injury attorney clearly did a good job for you. They did a good job. They got millions of dollars. That's a good job. Some people don't see that amount of money in a lifetime, although your friend was the one who suffered the harm. So ideally, yes, they need to be compensated. That's the whole purpose of this process. But to say that the lawyers didn't do a good job, I really cannot, because that is a very substantial settlement. Okay, both in the workers' comp field and in the PI field. Your situation involves a lot of different issues. Workers' comp liens, you're talking about appellate issues. It's all over the place. You got to do your chronology and tighten it up. You got to write it out. All right. And you may have done it already. If not, you have to, because it's more of an exercise. It's an exercise of getting your story tight, concise, narrow down what the issues are so that you can get the help that you need. Otherwise, there's a lot of other what we call red herrings here. I mean, cases take twists and turns. There's all different issues and interests and dynamics coming from all different directions. But in order to achieve your objective, let's make it concise and tighten it down to the key issues of what exactly you want addressed. And in your situation, it's the fee. We need to get this fee resolved. You're spending a lot of time in court, appealing, remanding back to the trial court. You could go up and down in the court process forever, and you'll never get your money. I think a quicker way, and you could do that for years and maybe get more ultimately at the end in terms of your net recovery from both the lawyers, the workers' comp or the personal injury attorney. You could probably spend about 7 to 10 years doing this. That's my anticipation based on my experience on the way you're proceeding right now. It probably would take you about 7 to 10 years to see even a penny from this. Whereas if you go to your attorney that you're having the issues with regarding the fee, send them a formal request to do fee arbitration, you could get it resolved right there. It could be an independent neutral who could be looking at your matter and then say, let's come to the table. This is what you guys should do. Does that make sense?
Yeah.
And or else you're going to be spending about 7 to 10 years doing all the appeals yourself. That's incredibly hard. Incredibly hard to be filing appeals. I mean, you could go get remanded back to the trial court, and then you could have appealed that decision again. You could be going up and down in the courts. So I think in order to save everyone here, I think a request for fee arbitration is appropriate. Does that make sense for you? And look,
I don't know how to do the fee arbitration.
Well, you write a letter. You write an email to your lawyer right now. Say, I request fee arbitration.
If they don't agree, you still have to go to the court.
I believe, and again, I've never been in a fee dispute with my clients because I accommodate them. I believe it's mandatory. It's when it involves a fee dispute, it is mandatory fee arbitration. But you have to follow the code. There, you have to make a request. You have to request it. You have to review your retainer. I don't know if it has to be included in the retainer actually, but I think by code, it's mandatory fee arbitration. So let's look into that.
Now, what about the damage? The maid, not to follow the contract, not to follow the agreement. Last time you said,
I'm sorry, man. I need to interject here because this is when I'm going to revert back to my initial comment of tightening your story up. I can't follow you. You lost me already. Signing a contract, didn't sign. Let's tighten your story up. I need you to, my advice to you is before we continue is to take about 30 to 45 minutes, maybe even more, and write out your story concisely.
Okay, you said that there is another way to after the decision come, then there's what or whatever petition to recover the cost of the extra cost by for the another side is improper action cause the further lawsuit, you know.
Ma'am,
Yeah,
I don't understand where you're coming from right now. So
yeah.
you need to
Some time
type.
ago, I asked you, but you said I forgot what the number of petition. You know, after the lawsuit, you said that you have to wait for the decision come. Then, if you are the winning of the decision, then you can ask another side to compensate, like a damage. You damage you got because of their improper action.
I understand, ma'am. I'm going to interject here, and I'm going to again ask you to write out your story in a concise bullet point manner, and then come back and maybe it will be more clear and I can help you better, because it's a little unclear to me. I don't know exactly what you're asking, but I want to give iPhone the opportunity to ask any questions he may have. I want to address everyone who's signing on here. So iPhone, can you hear us?
I can hear you, yes.
Oh, yes. So you were just listening in there. So litigation can be messy. And I think it's important to get your story straight. Write it out. I don't know if you've written your story out before, but it's an exercise of tightening up your situation, because they take all sorts of twists and turns, as you know, we've experienced here. It can get complex. Sometimes brevity, there's more value in brevity. Let's keep things concise and to the point so we can best help you. And I know you have a matter that's in litigation that's dealing with appeals as well. And perhaps if you, or even an employment matter, employment cases can be quite complex as well. They're very document heavy. A lot of depositions may have to be taken, and a lot of review of correspondence between the parties. So it's a lot of discovery. If you can, please send me a summary of your situation, and I'll do my best to find you an attorney who can help you. I'd like to ask if there's any additional questions here. We're at 1/2 past the hour. I'd like to keep these meetings generally brief so we can focus on what needs to be done and then attack our priorities for the week ahead. Any last questions? Okay. Again, I want to also ask if you guys feel like I've helped you in any way, if you guys are in any bit of a better position than when you first signed on. I think a good way to say thank you is to leave a positive, kind review. Although you're not required, I would be honored and grateful. The link is in the chat. Please feel free to sign on back here every Monday. I know things are complex, but what I can assure you is that more will be revealed. Legal matters they progress. And after each step, after each small step that's material, more will be revealed. So this is a great place to tap into a source of information that could possibly give you some insight and help you. And we're here every Monday morning, 9 a.m. It's a great time to stay connected, tap back into the source, because legal issues are substantial. They're significant. They have very significant consequences. So there are always priorities. So this is a good place to tap into, stay connected with your own issues, and attack it for the week ahead, the critical priorities that you need to take. And then come back here and let's share your progress, your wins regarding your legal matter. What do you need to continue to do, and what can you do better? That's what I can help you with the most is, what did you do that was helpful in your own legal matter? What should you continue to do? And let's reflect and see what needs to be done better. And hopefully you'll achieve the objectives that you set out to. and I'm here to be of service. Every Monday, 9 a.m., Coffee with a Lawyer. Thank you very much. I'd like to say take care, take action. Bye for now.